and welcome to the Divorce Lab. We're a group of independent professionals working to help educate the public on various topics related to divorce. I am Carrie Goldring, a certified divorce lending professional who specializes in mortgage planning.
And I'm Mark Avezai. I'm a certified divorce financial analyst. I work primarily in Troy, Michigan.
Hi, I'm Jim Chryssikos. I'm a family law attorney and mediator located in Troy, Michigan. So let's get started with today's show.
We're going to talk and explain some business evaluation and how prenups fit in. And we have Jim Chryssikos, who's a family law attorney and mediator. And we have Nick Papasifakis, who is an estate planning attorney. And Jim, I think I'm going to start with you.
Thank you. And usually what happens is you get a new divorce case, comes through the door. One of the spouses mentions there's a family business involved. So the first step would be, let's identify what is the business or what are the business entities? When did they begin? And usually it's one of two things. Either it's a business that was started during the marriage by one or both spouses. That's the easiest because then we know it's most likely a marital asset because it accumulated or began during the marriage. Even if the other spouse isn't named on the business paperwork, it would still generally be treated as a marital asset if it began during the marriage. That's the first question. If it turns out that it's not a business that began during the marriage. So for example, say a multi-generational family business of one of the spouses. Think about maybe examples being like a car dealership or law firm or something that's just didn't begin during the period of the marriage. Maybe it was a grandparent who started it and it's maybe subject to a trust. And then Nick would discuss a little more detail how those work. First need to identify that question. Is it a business that started during the marriage or is it a business that began prior to the marriage by one of the spouses or maybe extended family?
The approach obviously different if it's a marital asset versus what we call a separate asset.
Well, first of all, I want to make sure we're clear that right now we're talking, since we're located in Michigan, anybody looking at this is all this is all Michigan law we're talking about. So if you don't live in Michigan, just be advised that law could be different in your state. But yeah, if it's a marital asset or if it's not a business that began during the marriage and it was more of a family asset of one of the spouses beforehand, we're going to need to do a little bit of homework and additional discovery so that we understand how it's owned, individually owned by multiple members of one spouse's family. Is it owned by a trust? Was it owned by one of the spouses before the marriage individually? We have to look at it and say, okay, well, it was a premarital asset. So could be similar to, say, a home or a retirement account. We have to identify and acknowledge the fact that maybe it was accumulated or acquired premaritally, and there may be some portion of it that's not marital. But then we have to start doing an analysis of what about the growth in the business during the marriage. So again, similar to a home. Maybe I owned a home worth $500,000 when I got married, but if it's worth $1 million now and we're getting divorced, there's still $500,000 in growth of that asset over the period of the marriage. And the same could be true of the business. But a business is much more complicated because the reason for the growth could be, there could be a wide variety of reasons why the business grew during the marriage. And it may or may not be attributable to the spouse. So there's a lot that would go into that in determining, is there a marital portion to this otherwise separate asset?
The key part of the analysis is whether it's a marital asset subject to division or a separate asset, a portion of which may be subject to division. I know on my end as an estate planning attorney, a lot of times folks come to us before they're married, looking for ways to protect a long-standing family business or even just a solely owned business that they've built in that they want to protect prior to marriage. And that's a lot of times when we get into discussions surrounding prenuptial agreements.
Right.
And in Michigan, it's one of now 20 states that recognize what we call a domestic asset protection trust, which is kind of like a prenuptial agreement in that it can protect premarital assets as long as it's executed 30 days in advance of the marriage. The difference is that you actually don't need your spouse to sign off on it like you would for a prenuptial agreement. So we've seen that becoming more prevalent for protecting certain assets like a family business.
So what is the analysis there? If it's not a prenuptial agreement that the other spouse had to sign off on, what is the argument? How is it effectively protecting it from division in a divorce if it's not a prenuptial agreed to by both spouses?
Yeah, so that's a great question. So, but it's statutory in nature, meaning the law, the Michigan Congress had, enacted this law with specialized language that basically carved out a special provision that said if you create and fund this asset protection trust, which contains very specific provisions as to who can be the trustee and how distributions can be made, things of that nature, remain separate property, not subject to marital division.
Is that because is it taking the control away from the other spouse or the owner spouse, meaning they don't have control over certain things like distributions you just mentioned? So if it's not within his or her control, then it's something that the other spouse can't access either.
Yes, exactly. And so that is the special types of trusts. You need kind of an independent trustee managing when the owner can actually take distributions from the business. The owner can still maintain control over the decision making on the business. It's just when it comes time for distributing profits, things of that nature, in order for them to personally take a distribution from the trust, they need an independent third person that would say, yes, you can have a distribution. And so basically what, the legislature has provided is that there's enough of a barrier from control that would allow the spouse to invade those trust assets. And it's similar to, for example, if your parent or grandparent left money to you in a trust where you weren't the trustee, you couldn't demand distributions, difficulty for the spouse to argue, hey, this should be subject to division, because, the spouse who is a beneficiary of that trust would say, hey, I don't have control over when I get a distribution and in what amount. So how can this be considered, a marital asset subject to a split?
The trust then considered an irrevocable trust? Because
yes, it would be an irrevocable trust. Yeah.
Okay. So you wouldn't have a scenario where 30 days prior to the wedding date, spouse A creates this trust, and then 30 days after the divorce is final, sets it aside and says, oh, now I have all the access in the world that I didn't have at the time of the divorce.
In theory, no, right? But the trustee can terminate the trust at any point in time. So the trustee can decide at some point in time that, hey, this no longer makes sense because maybe you're not married anymore, right? And so the trustee argued the spouse couldn't demand that it be done, but the trustee could make that determination later that, hey, the reason for this no longer, applies. We were trying to protect it for the marriage. There's no longer a marriage. So I can give the reins back to, the spouse, which makes it a very interesting planning tool. Where we're seeing people do this. It just involves not having to have your spouse sign off on it.
I have two questions. So is this ever used when you have a company with more than one owner and they want to make sure that different spouses can't interfere with breaking up, taking assets from a business, or is it only when you have one owner?
So that's a great question. So we've seen it both, right? So we've seen folks who, as long as the other owners are okay with that protection trust owning the one co-owner's interest, then it would work. If they weren't comfortable with that, then it wouldn't be an option. But what we always recommend for our business owners is that they would enter into some form of a buy-sell arrangement that would contemplate the fact that, somebody could get divorced and we need to have some sort of protective provision in there for the other owners in the event that the business itself became, subject to this division. so that they're not stuck with an ex-spouse as a partner. But that's more on a business planning side than it is like an estate planning side. But that's what we see business owners do very commonly, is, they contemplate the fact that somebody's going to either pass away or go through a divorce. What happens to the business in that interest if it's subject to division? Jim, do you see similar in your practice?
What I see far more frequently is the other path that people take, which is the prenuptial agreement, to try to control what the outcome might be in the event of a divorce when there's a business involved. And that obviously is signed by both spouses. So there, hopefully, in order for it to be binding, there is that informed consent, that disclosure of assets and liabilities at the time of the marriage or when it's executed. And that seems to be far more frequent to see it try to be protected that way.
Thank you for listening to us today. You can find us on the divorcelab.com. You can feel free to take a look at our other episodes, and you can also leave some questions or comments for us on there as well.